I don't think it can be a sufficient ground to nullify the election, because when it comes to nullification, there's a totality of the entire process. This may be more or less like a blip, but not sufficient enough to nullify. However, I agree with the commander that there's still time, inconveniencing as such, but there's still a bit of time, and that's why my proposition would be, if the same can be concluded as soon as not more than the next 3-4 days, so that IBC can be given time to be able to adjust. But it is inconveniencing. We have a very, very small time to be able to have everything in place, and I think there need to be a watermark. The expectation was 30 days to the election. We are not talking about ballot papers. We're not talking about Kim's kit and all that. All those ones should have been done. I remember when IBC was doing a dry run of their respective electronic register and all that. As at that time, it was expected that we have already settled on issue of ballot papers and the candidates and what have you. But with the 2 court rulings that have come in quick succession, the one for running mates and this one allowing the candidates to be able to be cleared on the basis of not insisting too much on ID copies and signatures per county, I would think the time is very limited. It is possible, but the time is extremely limited. However, even if, for example, compliance may not be 100%, it cannot be the only basis for nullification of the election. In nullification, the threshold, I think, set by Justice Maraga is a bit clearer, and I don't think if 1 or 2 people are denied on a matter or an issue that IBC felt was right, may not be sufficient ground to nullify. However, what is important is what the court rules. The moment there's a specific court direction or a court order, IBC has no choice but to comply. The only issue is, I'm sure IBC is sufficiently represented in those matters in court, and their lawyers have ability to raise to the court that the time is running out, so that whatever orders the court give must be orders that are implementable within the time frame. What is important is that courts are equally good when giving orders. They never act in vain. They never give directions just for the sake of giving direction. They are mindful of time, they are mindful of possibilities, and there's no court of law that would want to give an order or a direction that knows that it is, with all due respect, impossible to implement. Let me give an example. You can't find a court giving an order that a candidate be added to the ballot 3 days to the election. That will be an impossibility. That one will be declared to have been overridden by events. But as we speak at this point, with the 33 days remaining, we have a very small window, and I think IBC will be able to raise the same in court. And as at the time the court will be giving direction, the consideration will be what is practical, what is possible within this limited time.